So you're driving down the highway, having a good day, you go to a store, you pull into the parking lot, and you get to one of those parking places and somebody's kind of waiting for it, and you are too, and you pull in and you're kind of like, sorry. Anyway, you get out of your car and the next thing you know, here's this guy in your face. And he is upset, and all of a sudden it turns into a self-defense situation. You have to defend yourself, take the guy down, put him in a lock, and now what do you do? Who do you call? So we're going to talk about that today, because today we have a lawyer with us, Mr. Andrew Page, who's going to help us out on the law and self-defense. Welcome everybody to Black Belt Life. I'm Darren Myers, and today we are going to have a great conversation with Mr. Andrew Drew Page of Randall Page Law Firm. And let me tell you a little bit about Mr. Page here. He's a very experienced trial lawyer. Went to Campbell University and graduated with honors, and then went on to Regent University School of Law, where he was published by the Regent Law Review. Pretty good, to say the least, and became chairman of the Regent Trial Advocacy Board. Then he graduated with honors with Regent and now serves as an adjunct professor of trial practice and advanced trial practice. He also travels with their national trial competition teams, and in 2018 and 19, his teams won the national pre-trial competition at Stetson's University of Law. He's also written a book that's on Amazon, The Right Defense for a Traffic Offense in Virginia. So that book just went to the bestseller list because of that, plug that we just gave him, of course. Okay. So please welcome Mr. Andrew Page. Welcome, Andrew.
Thank you. It's an honor to be here. I appreciate the opportunity.
Well, thank you for taking the time out of your very busy day, I'm sure. So tell us a little bit more about yourself.
Well, I'm originally from Greenville, North Carolina, so where I was born and raised. And after graduating high school, like you said, I moved to Boys Creek, North Carolina, to attend Campbell University, where I got my degree in government, and became very passionate about studying law, and which led me to Regent University. And my plan was actually to go back to North Carolina because that's where all my family is, but got an opportunity to work at a law firm in Suffolk, Virginia. And originally it was called Stallings and Bischoff, and then it changed throughout the last few years, and had an opportunity to buy into the partnership with my current law partner, Jack Randall. And so we bought the Suffolk office, and then we opened up offices in Cortland and Emporia. So essentially, we have a law office all along Highway 58 in Virginia.
Wow, that's interesting, the way you've laid that out. Fantastic. Well, congratulations. Quite a career already in your young life, of course. I tried to cover over the last couple of weeks some of the bare bone basics of the laws in self-defense. And I hope I haven't ripped them up too bad. But I hope you could tell us more of the specifics of those laws that we should be concerned with. So what is, first of all, the difference between assault and battery?
Okay. So an assault is when someone creates reasonable apprehension of imminent harm against another, and then takes some overt act, is the legal term, that creates that reasonable apprehension. So, for example, in your example that you started with, when you're driving in your car, you get out the mall. Let's say that you see someone there, somebody that's upset at you. Maybe we have our belt test, and they were upset that you didn't pass them because they didn't practice enough. I don't know.
That's tonight.
And they walk up. That's right. So they walk up to you and say, "Sensei, you should have passed me. I'm so angry. I'm going to knock you out right here." And then he doesn't do anything at all other than say that, and you go on into the mall, and then you try to press charges. that's not going to be sufficient because words are not enough by themselves to create assault. But let's say that he says, I'm going to hit you right in the face, and then he balls his fists up in the air. That can be enough to create reasonable apprehension that he's going to commit an offense. And to some degree, you wouldn't even have to necessarily know that an assault has been made against you. So, for example, let's say you're walking along the parking lot and that upset student is behind you. And he says, I'm so upset, I'm going to walk behind him and punch him in the back of the head. And so he walks up behind you and swings and misses, and you have no idea that he made that swing. But I saw it, and I reported it to the police. That person could be charged with assault and battery, even though you didn't even know it was happening.
Interesting. In that one example you gave where the guy raises his fists and says something, I had that almost exact situation where a guy had a stick and he says, I'm going to beat your face in, after an argument, he was kind of mouthing off, and all of a sudden, I'm going to beat your face in. I took that as, okay, that's it. So yeah. I was appropriate there, I guess.
Right, and the difference between an assault and a battery is a battery is an assault plus an actual touching. So if that person was coming up behind you and they actually touched you while they were swinging, even if it's a minor touch, that can be a battery. So even if he grazed you, as long as he touched you with the apprehension of creating imminent harm with that intent, that's sufficient for a battery. So a battery is an assault plus a touching.
Okay, so as long as someone touches you or has that overt act, and then also the fact that they could touch you without your permission, self-defense, how much self-defense can play into that kind of crime?
Well, I mean, it's critical if you're able to have a reasonable defense of self-defense. Now, while it's the Commonwealth attorney is the prosecutor in Virginia, like North Carolina has district attorney and so forth. But whatever the case, the Commonwealth or the district attorney has the obligation to prove beyond a reasonable doubt that a person is guilty of a crime. However, it is incumbent on the defendant to show evidence of self-defense in the event that they had, in fact, committed some touching. So in your scenario where somebody's walking up to you and they're saying, I'm going to punch you, and they raise their fist, you then take action and you punch him in the face and knock him out or whatever you need to do. You would then need to explain to the court and prove to the court what your circumstances were, and then it would be up to a judge or a jury to determine whether with that self-defense, the Commonwealth is still able to prove beyond a reasonable doubt that you should be found guilty.
Okay. So, and you've used that word reasonable amount of force. That's really what it all kind of boils down to, doesn't it?
Yes. So, if somebody's just walking up to you and pushing them, you're probably not going to be able to take out a weapon and stab them or shoot them, or something of that nature. But you can use force that's reasonable under the circumstances to repel the offender.
Okay, interesting. And as I understand it, there are two types of self-defense arguments in Virginia. There's what is called justifiable and then excusable. So can you clear up the differences between them? Absolutely.
So justifiable is when the defendant had absolutely nothing wrong that they brought to the argument. So in that example that we just talked about with you, where someone else raised their fist at you and let's say they tried to punch you and you blocked and you took action and you knocked him out, that's justifiable because you did nothing wrong to provoke the attack. So that's justifiable self-defense. Now let's say that you were having a bad day, and instead of that person coming up first, you decided you were going to attack that student for not doing their homework and not practicing before doing the test. And this is all, of course, completely hypothetical.
Very.
But instead, you decided to make a punch at that person, okay? And then that person leaves the mall, and then you leave the mall. Nothing else happens. But they see you later at the grocery store, and they say, oh, Hanshi attacked me, I've got to defend myself and provoke an attack. And so now they're coming back at you, and then you're able to defend yourself. So even though you were the initial aggressor in the first instance, you now are excused because it's essentially the fight was abandoned, and it had been retreated. There was no more fight going on. So now you are able to defend yourself, even though you were the initial aggressor at the beginning of the conflict.
Interesting. So in the case of an argument, like two people just going at it, having a big argument, and then all of a sudden somebody picks up a weapon or something like that, and you try to back away from it and just say, whoa, I don't want to have anything to do with this now, that also would be under the excusable?
More under justifiable. Because
okay.
if you're just arguing and there hasn't been any overt act on your part, remember, words are not sufficient alone to create an assault. It requires a threat plus an overt act. So if you haven't made an overt act, even if you're arguing, there still hasn't been technically an assault until there's an overt act taken, until there's some action, a raised fist, a push, or some movement that creates reasonable apprehension of imminent harm. So that would still be justifiable. There's a case in Virginia where there was an argument, a person initiated a fight, and then they said that they tried to retreat by taking about 15 steps back, and the person was defending themselves and attacked the initial aggressor, and that initial aggressor killed the person that he had initially just attacked. And he was trying to say that was excusable. But the court reasoned that was still all part of the same fight. There was never any clean break. There was never any true retreat, that he may have just been repositioning himself to gain an advantage in the fight, which obviously he did. So there would need to be some clear, I'm trying to retreat, I shouldn't have started this, I'm sorry, and then some attempt to flee. And then if the person defending themselves continues to attack, even after the initial aggressor abandoned the fight, then that initial aggressor is excused to be able to defend himself from the person he initially provoked. Does that make sense?
Sure, yeah, it definitely makes sense. Now, the one thing I think I'm a little confused with is this: in Virginia we have what we call a stand your ground law, and which basically says that a person does not have to retreat before using force. So does that kind of contradict with that excusable self-defense or justifiable? How does that apply?
No, it doesn't conflict with it, because first of all, for justifiable, you have no obligation whatsoever because you were at no fault in the fight. So you have no duty to retreat. If somebody commits an overt act to you, then you have an absolute right to defend yourself and stand your ground. You do not have to try to leave. Now, obviously, we always try to recommend, if you can escape a fight, try to escape a fight. But in Virginia, at least, you have no duty to seek to retreat in order to be able to defend yourself. As far as the excusable is concerned, the stand your ground would only apply once that initial fight had been abandoned. So you don't have an opportunity to stand your ground when you're the initial aggressor.
Okay.
So if you are initiating a fight and then that other person is defending themselves, you don't have the right to stand your ground. You are the aggressor. The other person is justified in defending themselves. But if you're getting beat up or whatever, or even if you're winning and you have an epiphany, I should not be doing this, and you tell them, look, I'm sorry, I shouldn't have started this, and you try to leave, and then they re-engage, depending on the facts and circumstances, then you may be able to have an opportunity to stand your ground. But the excusable is the only one where the stand your ground may have some conflict.
It sounds like a good situation to have a lawyer in.
Right. Excusable is very, if you're starting a fight, you're going to want to make sure that, A, you don't say anything to the police, just don't make a statement at all. And then secondly, understand that if you initiated it, it's going to take a lot for you to be excused to be able to defend yourself later. So it's always better not to start the fight. Just if don't ever go looking for a fight, I guess is the best advice you can have.
Absolutely, absolutely. And I think you brought up a great point that when something happens and you're going to be all psyched up, your adrenaline has pumped, whether, even in a justifiable situation, especially in that, because you're probably surprised, is that when the police come, you probably want to, and I've always taught my students that you tell the officer you want to cooperate completely, but I'd like to talk to my lawyer first.
Yes, always. Never talk to the police without contacting a lawyer, because even if you were justified in a fight, you may still have to go through all of the legal processes, get arrested, because they weren't there. They're going to rely on the statements that they hear. So if you're not sure that it's 100% justified, or even if there's a potential risk, I always advise people to say, you have a right to not incriminate yourself, and that goes to both guilty and innocent people. It doesn't matter. The Fifth Amendment is there to protect everybody from having to essentially testify against themselves. So it's best to make sure that you consult with an attorney before you contact the police, and make sure that it's a justified self-defense or an excusable defense. And if you were the initial aggressor, you definitely don't want to make a statement without talking to an attorney.
Absolutely. And the thing, I think most people get in the situation, where something's happened like this, and they're so pumped up, and of course, especially if it's not their fault, they want to tell the police about what the bad guy did. But
sure,
in those situations, you can say things that you wouldn't have normally said, because you are so, right. It's such a traumatic experience.
Yeah, I mean, innocent people, unfortunately, say things that they shouldn't say, and it's been proven that there are innocent people who are found guilty based on their false confessions or their mistaken confessions. And so even if you're innocent, it's best to politely and cooperatively decline to answer any questions of law enforcement without the presence of an attorney. And if you invoke your right to an attorney, or you say, I want a lawyer before I give any statement, they have to stop asking questions, or anything that you say cannot be used against you. So invoke your lawyer, and then you can always, if you're innocent, contact the police with your lawyer to make sure that you don't say anything incriminating.
Okay, gotcha. So with that situation, though, you're probably in a lot of different self-defense situations. You're probably going to be cuffed. You're probably going to be taken to the precinct because you're not telling them anything. They don't know who the bad guy is, the good guy is, usually in those situations anyway.
Well, you may get arrested typically with these types of, as long as no one is seriously injured, you may just get a summons. They may just essentially, it's like writing a ticket. Okay. And, you still have to appear in court and all of that. If they do take you in and this is your first run in with the law, generally you'll get they'll take you to the station, they'll fingerprint you. Don't say anything other than identifying information that you're required to say. And, you'll be released, rather quickly. I mean, now if you've got a significant criminal history, then you may end up staying a little bit of time and have to, request a bail hearing and all those types of things. But generally, if you have a fight that is a he said, she said, you're not likely to spend a night in jail generally. Okay.
Well, great. Good. Now, what is the castle doctrine? I know some states have that, and Virginia does. How does that play into self-defense?
So if someone breaks into your home, you have an absolute right to defend yourself, and there's absolutely, of course, no basis to retreat. I actually have the case here. It's Hines versus Commonwealth. That's Hines versus Commonwealth. It's a Supreme Court of Virginia case from 2016, and I wanted to read the words exactly as they said it. The defense of the castle doctrine provides that a person is not obliged to retreat if assaulted in his dwelling, but may use such means as are absolutely necessary to repel the assailant, even to the taking of life. So you have an absolute right to defend your home, and even if that means you have to kill somebody to protect your family and to protect your life, that is an absolute defense. Now, there's a difference between defending property and defending lives. If somebody steals your property, obviously you can't kill somebody to protect your property. But if you are in fear of your life or you're in fear of your family's life, you have an absolute right to take whatever actions you need to make your family safe. And you have no duty to flee your home. It's your home. So you can stay in the home and defend yourself and not get in any type of trouble for that.
Good. I'm glad that you read that, because that clears it up very well for me. I appreciate that. Now, one thing I didn't mention in your accolades is that you are also a martial artist. You're one of my students. So that kind of gives you a look at both sides of this as a martial arts student as well as a lawyer. And are there potential problems for martial artists in a court of law? Because what I have heard is that sometimes the courts will look at us a little bit differently.
Okay, so the general rule is that a martial artist is no different than anyone else. I mean, you can use whatever means are necessary to defend yourself. Where it may come into a problem is if you are an initial aggressor. So if you're starting the fight and you have some knowledge, beyond the common person, so that you could, inflict a deadly punch or a deadly kick, and you actually follow through on that, or you have a ability to significantly impair someone as an initial aggressor, and you do that, then the courts are going to look at you, more significantly. So the general rule, and I brought the case for this one, and that's Johnson versus Commonwealth. It's a Virginia Court of Appeals case from 2008, and it says, fists may not indeed be regarded generally as a deadly weapon, but they become most deadly by blows often repeated, long continued, and applied to vital and delicate parts of the body of a defenseless and unresisting man on the ground. So the general rule is that your fists and your feet, your body, is not a deadly weapon, even if you're trained, but it could be used to be one if it serves the wrong purpose. And some of the factors that the courts have looked at for even, let's say, a single blow, because there has been a case where even one punch was considered assault with a deadly weapon. And what they looked at with that was a couple things. First was that the person that they attacked was unsuspecting and unprepared. So let's say we're walking down the street and there's somebody that you plan to attack and they're not looking, and you just haul off and punch them right in the temple. They're not looking. They don't have a chance to defend themselves. That's a factor that the court could look at. Another factor would be the degree of force that was used. So in this particular case, it was a punch that was so hard that it knocked both the assailant and the victim down on the ground. I mean, it was such significant force. And then the other one is the number of times that the thing is used as well. So the factors that the courts will look at as to whether it's a deadly weapon. But in all the cases in Virginia, the only time someone has been charged with assault with a deadly weapon where fists are involved is when the person is the initial aggressor and they took that type of action.
Okay, good. Wow, that's a lot of really good information. So really it comes right back to that idea of you've got to use a reasonable amount of force, because a good trained martial artist could deliver a punch and pretty much take out an average person quite significantly with that punch. So being reasonable in your amount of force to what force is put against you is what's so important.
Well, I'll say that would be wise, but what I'm saying is that the law on this is if you're the one starting the fight is the only time that's used. So let's say that somebody is punching at you, and you make a move to punch them, and you punch them hard, and you knock them out or I mean, even kill them. If they were the initial aggressor and you are truly defending yourself, you can take whatever action is necessary with your hands to defend yourself. But you can't just start a fight, with the intent of killing somebody or even the point of, significantly impairing them with your martial arts knowledge. But there's somebody's fighting you and you know that there's you're in fear of bodily injury. You can punch vital parts. You can punch, where the pressure points are and things of that nature to protect yourself. And again, you have that right to defend yourself. So mainly the main point is, if you've studied martial arts, you need to be very careful about starting a fight. Make sure that if you feel like you're experiencing an assault, that it's truly an assault if you're going to take that type of action. That's really where the martial arts comes in. Self-defense, if you're defending yourself from an attack, you do what you got to do to protect yourself. But if you're going to be the first one to throw a punch, you better make sure that it's justified or excusable before you engage, especially if you're going to use an attack on a vital organ or on a pressure point.
Excellent. Good. So if an average citizen were attacked and they successfully defeated an attacker, what's the advice of what they should do next?
Well, the first thing, of course, is make sure that you get in a safe position. You've successfully defended yourself. Make sure that you get to a safe, secure location. You don't have to stay on the scene. Go somewhere safe. The second thing I would tell you to do is contact an attorney, get a consultation, and make sure that you explain to your lawyer what's happened. Then, under the advice of your attorney, contact the police to the extent that the attorney advises you to do such, and give a statement, based on what the attorney has suggested that you do, and then just do what your attorney tells you to do.
Okay, great. Well, that's definitely good, because most people would think first thing, dial 911. And I'm sure in some situations that's probably is the thing to do, but talk to the attorney first. Good.
Yeah. I mean, if the person is unconscious or dying or something to that effect, obviously, call 911.
Right.
But you can tell 911 that you're also calling your lawyer as soon as you notify 911, so they can get the person out there. You don't need to just stay on the line like they always tell you to do. Call them so that way you can get the emergency people there, and then call your lawyer, and then make yourself available as the lawyer sees fit. Excellent.
Good. As a martial arts instructor, I try from time to time to teach especially my most advanced students about some of the possible outcomes of self-defense from a legal standpoint. And I think that really should be a responsibility of every martial arts teacher out there to do that for their students. So what's the best advice, the best legal advice you can give the martial arts community concerning self-defense?
Sure. So the best advice I can give anybody is always consult an attorney before you talk to law enforcement. Always. There is never a good reason to talk to law enforcement without an attorney, unless they're a family member.
Right.
and only talk to them about Thanksgiving and Christmas. Don't talk to them about your case. Okay? There's never a good reason to do that. So that would be number one, is never talk to law enforcement without consulting an attorney first. The second thing is, even though you do not have a responsibility to retreat, I would always suggest, and I know all of my instructors, including you, have always said, if you can get away from a fight, get away from it. And that'll help you in your self-defense argument. You're not required to do it, but why wouldn't you try to do it? I mean, we all know that even if we're successful at blocking and kicking, those things still cause impact on our body. So if we can save our body by running away, and it's safe to do so, run away. It's okay. You don't have to be a hero. We take self-defense so that we can defend ourselves if we have to. But if we don't need to, we don't have to be prideful and show what we have. It's better to let the situation go. There's been lots of times I think I could have gotten in fights with people, and I don't think I would have had any trouble taking care of myself. But what point is that going to serve other than, oh, I get to brag about it? Who am I going to brag about it to? I mean, nobody cares.
The guy next to you in the cell.
Yeah, exactly. So if you can get away, just get away. And then, finally, you don't need to fear the law if you did not start the fight. So if somebody starts the fight, don't be afraid. Do what you have to do to protect yourself, and then, follow through as safely as you can, and then call your lawyer as soon as you're done taking care of business.
Fantastic. Well, great advice. And Drew, I can't thank you enough for taking the time out today to talk to us about us and really clearing up a lot of things. How would somebody get in touch with you if they needed some legal advice?
Sure. So the best way to get in touch with me is to call my Suffolk, Virginia office. Say this, that if you have an emergency situation, let's say you're in a fight and you're not sure what to do at that moment and you would like to call me, my cell phone number is 757-636-7881. Only use it for emergencies, okay? If the police are at your door, or you're in a street fight and you don't know whether to call the police. But if it's not an emergency situation, then call my office and we'll get you set up for an appointment and consultation.
That's great. And I'm going to replay this so I can write down that number. So I have that in my phone. Drew,
Excellent.
Thank you so much for your time today, for your expertise, and love having you and Ainsley as students. You guys are just wonderful. And I've got to point this out to just the whole martial arts community. You all started during the pandemic, and you live probably, 40 miles, 50 miles from the dojo. And you started online, and you have continued with that. And I got to say, you guys have done a tremendous job learning karate online. Now, tonight, you all are coming to the dojo because we're having testing. And
Right.
Good luck to you guys with that. And please don't get in a fight with me about whether you make it or not. Okay. But great job to you and Ainsley. And it's a pleasure having you as students. And again, thank you for your time today.
Thank you. It was an honor to share with you all.
All right. And again, if you need a good lawyer, look up Drew Page. And we thank you for being with us today on Black Belt Life, and we hope you've enjoyed it. If you like the content, hit that like button. If you're new to this channel, subscribe, because we're going to be doing all kinds of things like this, not just about the law and self-defense, but how to protect yourself. And we're going to be interviewing a lot of interesting people coming up in the very near future. So stay tuned, and we'll see you next week.